everyone, and thank you for coming today. I just want to take this opportunity to thank you and just ask you if you wouldn't mind to keep your cameras switched off and yourselves on mute so that we can have this all go smoothly. So I just want to take this opportunity to introduce Richard, who will be talking about the future of probation court in services.
Thanks, Nat. Much appreciated. Good afternoon, everybody. It's fantastic to be here. I'm joined with my colleague Kelly Masters, who will be answering your questions in the sidebar if you have questions to ask during the course of the presentation, and with her expertise will help me out with some of the tricky questions that may come in the Q&A after. But anyway, a big welcome to everybody. This is a real privilege to sort of run through the future of probation service to the courts, and how we are aiming to maximise value for the judiciary in making sentencing decisions, whilst at the same time creating the best conditions for success for those people on probation who we work with, whether that actually is on a community order or through their time in custody and then later on a post-custody license. And this presentation will show how we intend to do that by increasing the quantity and improve the targeting and quality of advice that we provide to the judiciary, and some of the innovations that will help us achieve this. Next slide, please, Matt. So before we do that, I think it's really useful, particularly for those people who haven't got a probation background, just to explain why we have probation court teams at all. Therefore, and it's a reminder, and it's also a reminder for those that do have a probation background, that the future is very much grounded in grounding our services to court in the purpose for being there, which sometimes gets a bit lost. So to start with, if we could go to the next slide, please, Matt. Just to remind everyone that in the Criminal Justice Act of 2003, it states that the sentencing judiciary should obtain a report to explain details about the analysis, about the offence, whether that be sort of motive, the thinking and the awareness and perhaps the culpability of the individual that committed the offence, the victim impact, any sense of remorse that that individual may have had, whilst also looking at previous patterns of offending and see whether this behaviour was unusual or part of a persistent pattern, setting the context of the circumstances of that individual that may have led to the or contributed to the motivation for the offence, and whether that points to anything in relation to the risk of further offending or further harm. And then one of the things that we are really keen to ensure that we improve in the future is to make sure that we have detail of the victim impact and remedy the fact that at the moment we don't currently get access to the victim impact statement, which would be vital in terms of our being able to explain that in the context of the details relating to the defendant. And then the Probation Service offers the court a proposal on sentence, especially if that's for a community order where that's appropriate, and given that the Probation Service deliver most of the available community sentences following unification of the service, then we are best placed to explain and inform what choices the court have in relation to the particular offence and the defendant before them. What also is stated in the Criminal Justice Act is that if the court don't think it is necessary to order a report, then they don't necessarily have to, and I will explain why that is relevant in time. In terms of the way that we currently get requested pre-sentence reports, that it is a matter of waiting for the judiciary to ask for one. But what we know is that in terms of people going through the court, that it would be far more helpful and a better value to the judiciary if we were able to identify those people who are likely to have a higher level of complexity or are in other ways disadvantaged going through the court. So we will actively target and identify those cases to seek a request from the judiciary relating to people who are at risk of short-term custody and therefore the loss of their liberty, for women who may have experienced trauma, and young adults who have issues around maturity, people from an ethnic background who may also have experienced discrimination, and we will also target those people, those cases where there is likely to be a vulnerable victim, by which we mean those cases where there's been a sex offence, domestic abuse, or safeguarding. Next slide, please, Matt. So, and this is that targeting of cases is supported very much within the government sentencing white paper called A Smarter Approach to Sentencing, and what that does is intends that we should continue to provide reports on dangerousness and public protection, and highlighting the need for punishment where that is appropriate. But in terms of 3 and 4 here, it is also very much more, as I've just suggested, about tackling the many cases where there are complex issues and complex causes of offending, not least of all around substance misuse and mental health, but also in relation to people's lived experience and the host of different reasons as to why people come to the court. And we feel that if we identify those cases in advance, then we can highlight to the court where they feel that they may get the best value. They, of course, do not have to agree with the suggestions to request pre-sentence reports. It is always a judicial decision, but we think it would be helpful in order to be able to highlight those cases where there is probably most benefit from having a pre-sentence report. And also for number 4, then this is about identifying those people where there is a high likelihood of there being success in people turning their back on crime, as it's stated in the sentencing white paper, and after a history of being involved in the criminal justice system. And this is where the government are looking at different types of high-end, high-threshold community orders that would support both rehabilitation and public protection. One of the concerns that is highlighted in the in sentencing white paper is the confidence of the judiciary in community orders, which is something that will be a thread through the whole of this presentation on the future work of probation in court, which is about building the confidence of the judiciary in the community orders that are offered as often an alternative to custody. Next slide, please. So the probation court teams aim to support the delivery of justice as an integral part of the justice system, and this is done in a way that all probation functions provide the service, and that is first of all through assessment, and I've just shown that is based in statute in the Criminal Justice Act, and also then through protection. This is partially achieved through the proposals within the report to suggest proportionate measures to protect the public, but actually it's also there to be responsive to the immediate risk of harm that may become apparent while someone is going through the court. So there may be safeguarding issues that need to be addressed immediately. Someone who may be a high risk of serious harm may be known to the Probation Service and perhaps already part of multi-agency public protection arrangements, in which case the court report writer will need to be part and parcel of those arrangements and contributing to the management of that person, but even as they are going forward to be sentenced. And in terms of rehabilitation, this will be again partially about what is presented in the report as options for the court to look at rehabilitative measures, but also actually to start the process immediately by engaging that individual, supporting their motivation, and also then making referrals as and when necessary to be able to support stability and engagement with the community order, if that is what they receive, with statutory measures like a duty to refer to which is a responsibility around homelessness, but also engagement with the health service and other services who may be involved in supporting that individual once they are on their sentence. So assessment, protection and rehabilitation are the three corners of all probation work, but in terms of the courts, they are very particular to the context of working in a host institution while someone is primarily going forward to be sentenced, and this is done both pre and post sentence with those individuals. Next slide please, Matt. So with that said, that being the reasons for probation services providing a service in the court, the objectives of the National Operational Court Strategy are as were stated on the title slide, and that is about increasing the number of reports that the amount of advice that we provide for the court, so that we can target interventions but also make sure that we are working with those people who will benefit from having a pre-sentence report, and also who will have benefit from any measures that are provided by the probation service to address that complexity, if they are willing to engage and comply with the community order and the offence seriousness leads to that conclusion. We also would like to inform the judiciary of the different types of interventions that are available and the ones that have the best evidence for success. We know that if people on probation are mistargeted and they end up in an intervention that isn't correct for them, and sometimes that results in someone being brought back to court because they are unsuitable to be in that particular intervention. And so where we are able to provide that advice and give the court a steer on what is the most likely to work, then clearly that is helpful information, particularly if the judiciary have not been able to access training or other sources of information that give detail on the services provided by the probation service. We want to provide the right start by engaging people in the court, and as I say, constructively provide motivation and practical support to increase the likelihood of their success, and basically hand over the information that we have worked within the court to those who are responsible for managing the sentence, so that they are able to work effectively with that individual when they arrive for their induction in field offices. And finally, the point I haven't mentioned, but is always necessary when it comes to working with the courts, and that is where we have to have the right delivery. So on those people who are responsible for managing the sentences also have to be responsible for the breach of an order if compliance is not there, and therefore it means that in order to maintain the confidence of the judiciary, we have to show that the sentences will be run well and that justice is served. As I say, a primary purpose for being our services in the court is that we support the administration of justice, and our involvement in the prosecution of breach is part of that. Okay, next slide please. So we're keen to increase the number of pre-sentence reports that we prepare and the targeting as described, because pre-sentence reports do influence and inform sentencing decisions, and we have feedback from the judiciary to say that they find them valuable. So there are two sources of evidence for this, and one is much more broad-based, which is the feedback we have from the judicial survey, which is conducted every year, and is also part of 4 of the questions from that survey form part of our performance reporting to show that we are improving our the confidence and satisfaction the judiciary have in our services. What we ask here, as you can see, is does the pre-sentence reports influence your decision about an outcome in any of the following ways? That you have imposed a community order in place of custody, and you can see that in that instance that 85% of respondents said that it had. That a suspended sentence, that you've suspended a custodial sentence, very similar proportion, impose certain conditions or programs. And this is key, because actually when we do propose rehabilitative interventions and the court are minded to pursue a rehabilitative route, then there is often agreement, and you can see that in 97% of cases that the judiciary have said that they have imposed certain conditions or programs on the advice of the probation service, and that They've not imposed certain conditions or programs, and again, an 85% positive response in that respect. So actually, what this shows quite clearly is that the advice provided by the Probation Service in not only providing objective assessment, but also in terms of making the proposal of what the right evidence-led sentence could be, there is a positive response from the judiciary in the survey. The other bit of evidence, which is actually it's a small scale, but nonetheless important in terms of who the advice was, the feedback was provided by, and that was the senior presiding judge and a deputy senior presiding judge provided a virtually a poster to say pre-sentence report work is essential, and that is a big endorsement from the Judicial Office to show that the work of the Probation Service is valued. The next slide, please. And one of the reasons why it's valued, this is a complicated diagram, and I apologise for that, but essentially we don't look to influence the judiciary for the sake of influencing the judiciary. Often there is a view that short-term custody doesn't have the long-term benefits that would come from a rehabilitative approach, but nonetheless we perfectly respect that the judiciary will sometimes impose a custodial sentence because someone has simply come to the end of the chances that they have had, or that there is the offence is serious enough for that to be warranted. But what we do want to do is influence as I say, the targeting of people on probation to the right interventions that are most likely to work, but also to be able to regulate the inflow of work to the Probation Service from the court, from resettlement, as people are released from prisons, and understand the relationship between the proposals that we make and the predictability of the work that then will come through if we are able to, if the judiciary agree with us more frequently. Where the judiciary in certain instances don't agree with us quite regularly, or simply don't ask for pre-sentence reports, we are then less able to predict the amount of the work that comes through. And what that means is that the planning of the available supply side is much more difficult, and it means then that we can end up with, if we have too much demand coming through, end up with backlogs, and if we have too few coming through, we end up with non-viable interventions because the numbers are so low, in which case then people end up waiting for longer one way or the other. This is not in any way to say that we want to regulate decision making of the judiciary. We just simply want to be able to get a higher level of concordance, if you like, between the proposals that we make and the independent decisions of the judiciary. And where that is not the case, then of course we will need to look to improve the quality of our reports to be able to support a better concordance. So it's really about the next slide, please, which is about how we are able to improve the coherence of the interventions that we provide for people on probation. So if we have a large backlog, and that means that people have to wait, then the result for the person on probation is that the sequencing of the supervision on that community order is out of kilter. They don't get the behaviour programme or the unpaid work or the other measures that are needed to have the desired effect at the right time. It also means that for the person on probation, then clearly the immediacy of the effect of the sentence is not the way that they experience it, and so therefore its benefits are reduced. And so what we're aiming for is that we can actually build on, for someone who's going through, excuse me, a rehabilitative measure, is that we can manage to stop the harm, and we can manage crisis if that is the case, introduce a behaviour change programme and new skills, and that for that to be consolidated and sustained in a coherent sequence of activity. So to be able to achieve that, we need to be able to plan and and provide services at the right level to meet the right demand. And this is, as I say, it's more about the shape of the workload coming through rather than any attempt to prescribe the numbers coming through. Okay, next slide, please. So in order to achieve this future vision of better quality advice, more and better quality advice, better targeting for people on services, ensuring that we are regulating the flow of work coming through and getting people to, and so that people on probation have a coherent experience that is sequenced in a way that they will understand and make benefit of, is where are we now? So we need to look at the current position. So next slide, please. This is a slide that just simply shows that in terms of the Criminal Justice Act clause that says you do not have to request a report if you feel it is unnecessary, is actually since 2010 an increasing number of the judiciary have felt that it is unnecessary, and we've been having a drop in the numbers of pre-sentence reports requested since 2010, and that means also then we will need to work with the judiciary to be able to establish with them what they consider to be the value that will help increase the number of pre-sentence reports and that information and targeting that comes as a benefit of providing pre-sentence reports. Next slide, please. And in this slide, what we're essentially saying is that the ambition to improve targeting is very much to the fore, with the groups that we've identified as priority cohorts, so that's women, young adults, people from an ethnic background. Between 30 to 40% of those people who have experienced trauma, discrimination, or have issues around maturity do not currently receive a pre-sentence report. And in terms of addressing some of the issues of disproportionality within the justice system, and also addressing some of the concerns and complexities of those three groups, then there's something that we need to address. But that bottom statistic is the one that has attracted our attention most, and that is that of those people who receive a short-term custodial sentence, only 11% of them get a pre-sentence report, which is a remarkably low figure. That's not to say that no advice is provided to the court on those cases, because there will be those who have received a breach assessment, or maybe are known to us and therefore perhaps the court have received informal advice or a previous pre-sentence report. But even if you increase that number to 50%, it still is a very low number of assessments with guidance and advice on the available options for people who are about to lose their liberty, and increasingly that is the case. So but one of the difficulties about being able to target those people who receive a short-term custodial sentences is that you only know that they are at risk of a short-term sentence with some certainty after they have been sentenced. And so we need to have a mechanism by which we can identify that group in advance, so we can signal to the court, this is someone who is likely to lose their liberty, or is at least at risk of losing their liberty to a short-term custodial sentence. Would you want to have a pre-sentence report for this person? So next slide, please. And then, having targeted those individuals, I guess the question is then what is the right outcomes that we are looking for? Bearing in mind that sentencing clearly is a judicial decision and independent, but what we are going back to the point about understanding how the inflow of work will be when sentencing has occurred, and also in terms of how we provide options to the judiciary, whether it be around the purpose of sentence in terms of rehabilitation or punishment, and reparation, etc. The question is what is the right level? What is the right percentage of outcomes that we're looking for here? And on this the right hand side, this shows the relationship between community and custody custodial sentences, and as you can see, in terms of the general principle of reducing short-term custody by promoting and gaining confidence in the number of community orders that are proposed, you can see that in 1 month at the end there is a trend in the direction that we would support. In the left-hand graph, what this is basically, interpret the acronyms, apologies for those. Rehabilitation activity requirements is blue, unpaid work is orange, accredited programs yellow, and community sentence treatment requirements is the lighter blue shade. And what we can see there is that actually, in terms of looking at CSTRs in particular, that line is very low. Only given the number of people who come through the court with substance misuse and mental health problems, for there only to be 12% of all requirements made for treatment requirements, we recognise is too low, and therefore that is one area we would look to increase the number of treatment requirements that we propose. And we don't anticipate that the courts would see this in any way controversial, because it is its main competitor, if you like, is the accredited programme, which is equally a rehabilitative measure. But what there tends to be is proposals for accredited programmes when probably treatment is the primary requirement needed. And there are a whole host of reasons for this. Not least of all the more complicated relationship that is needed with the health service, but these are measures that we are improving, and particularly working with liaison and diversion early assessment in the court, so that we are equipped with the assessments required to be able to be confident in our proposal of CSTRs to the court. But as you can see, we are monitoring exactly how the quantities and the proportions of requirements play out, and we'll look to adjust those in accordance with the evidence that we have, and also the priorities that are coming through from government investment. Next slide, please. So just to finish off this kind of where are we question, in a little bit more detail. A year or two ago, because of the big drop in pre-sentence reports requested, the Ministry of Justice Implementation Unit was commissioned to conduct a survey into a kind of state of the nation, if you like, of probation service work in courts, and come up with first of all, an explanation as to why pre-sentence reports were dropping in the numbers that they were, the request for pre-sentence reports were dropping in the numbers that they were, and then also what might be done about it. And so their first observation was that the statement of that the purpose of pre-sentence reports had become somewhat lost. So whilst it was supported by the government, it wasn't as valued by the judiciary as it should be. And I say should be in as much as that the onus is on us to improve the quality and the value of pre-sentence reports, so that the judiciary seek to seek the advice and use them, and also that actually there was some confusion amongst probation staff as to precisely the purpose of the pre-sentence report, and that is because we have become much more or too focused on process and format rather than precisely what it is intended to achieve. The second point is that there was a need to review the balance between the quality of advice that's provided through a pre-sentence report and the need to avoid delay in the court. So we know that since 2015 there have been reforms for HMPPS, particularly in terms of avoiding delay in the court. We subscribe to the view that justice delayed is justice denied, and that is very much in the interest of the victim for a court case to be dealt with quickly. But at the same time, if we are to be able to provide quality verified information that provides a confident proposal on the correct and evidence-led intervention, then that sometimes needs more time than the court are able or willing to give. And that means that that sometimes reports are not requested in order to maintain the speed and throughput of cases going through the court. And thirdly, the implementation unit found that the National Probation Service court teams were under-resourced, and also because they work in a host institution where they were having to manage some of the competing agendas and priorities of different services within the court, and because of the relatively low status, not being a legal service in the way that others are in the court, morale was low as well. And the upshot of that was that we needed to have a much stronger relationship with HMPPS and our judicial colleagues in the court in order to be able to problem solve around the tension between quality and the avoidance of delay, and actually do some actively work out how to manage some of those tensions to the benefit of justice. And the final point about reputation, I think, is already covered in the morale issue. Is that probation staff often felt that they had a lower status in the court, and therefore for their voice was less considered. One of the things that we had to recognise and own in the probation service was that training, I think, probably was insufficient for staff in the court, and that definitely needs to be remedied. So, next slide, please. So, building the solutions. And changing the probation service to courts for the future. So the next slide, please. So as mentioned, there's lots of work that we need to do around engaging the judiciary to build confidence, but also to explain and provide information, not only about the work that we do in the courts, but the success of the work that we do in managing the sentences that the judiciary pass. And there is a revamped and revitalised judicial engagement plan that starts with the creation of the judicial forum at a national level, but actually most importantly extends through to the dialogue at a local level, supported now by a protocol between HMCTS and HMPPS that also supports better and wider partnership working in the court with shared purpose. In terms of the whole development of products and services that have a clearer purpose, we are designing and improving the system, and we'll talk about the ICT infrastructure that supports that shortly. We are creating and have developed a new continuous professional development offer that is about building the confidence and empowering our staff to work professionally and assertively within the court environment to ensure that we are able to give the best advice to the court and suggest where we think that there are benefits to producing pre-sentence reports on particular cases, which is that point about improved pre-sentence report targeting, the increase in volumes, but also at the same time the increase in the quality. And I'll talk a little bit more about the PSR pilot in a second, which is looking at quality. In terms of the work in court that is not related to pre-sentence report writing, there are measures that are very much needed to support the increase of the request for pre-sentence reports, but it's also that case management and protection and rehabilitative work that I was talking about, and we need to properly decodify the roles and tasks that are undertaken in the court in order to make sure that we are hitting outcomes that are going to support that good, the best start for the person on probation post-sentence and the best service for the judiciary pre-sentence, which relates to the next one. And then in terms of service modelling, we need to make sure that the court teams are properly resourced and that we are able to understand the demands on court teams, which will come from we haven't got a workload measurement tool as yet, but what we have is the productivity analysis that shows what the demands on court teams are and the resource that is needed to manage the work that's coming through. And bearing in mind that because of the pandemic, the forecast increase in demand through the courts and probation court work in particular was about 50% increase in 22-23. So there is no way that we will be able to manage that increase in demand without recruiting new staff. So those are key foundational elements that we need to improve in order to get a strong court team, a court service for the future. But alongside that, we have run, or are running, or have run, about to run, and still running 3 pilots. So the have run pilot is the bail information pilot, which concluded last year, and it proved to be successful. It was run in parallel with a similar service from the prisons, and what we will move to now is to produce the business case for a dedicated HMPPS bail service that is operating both in courts and in prisons to look at the remand population. The pilot that we are running still, and we have secured an extension for the pre-sentence report pilot. It's just subject to agreement from the senior presiding judge, which we are hopeful to have shortly, but the funding has been agreed by HMPPS. And the PSR pilot is looking at how we improve the value of reports for the judiciary in the way that I have mentioned repeatedly through this presentation. And the final point pilot that we're involved in is for problem-solving courts, which, for those of you that know, will be aware, target and look at how to work alongside the judiciary in courts that are specialised around substance misuse, domestic abuse, and working with women offenders. And the evidence of that will suggest whether or not that more direct engagement with the judiciary provides a powerful improvement in the successful outcomes of those cases just mentioned. Next slide, please. And so, in terms of again the right cohort, right sentence, right start, objectives, what we have is the areas that I've just mentioned: improving products and services, judicial engagement, continuous professional development, and performance and data. But what I want to just do now is to concentrate on the technology side, just to show some of the innovations that are going to technology is always going to be part of a future service demonstration, isn't it? So if we could just move to the next slide, please. So we need technology as a work stream to look at how we support the whole system. And if it's targeting, we need to be able to identify our target groups effectively and efficiently, and also then need to be able to track and record and track those cases through the system, and other cases for that matter, to be able to ensure that we are highlighting them at early morning meetings with our HMCTS colleagues and others, to make sure that they are listed for, or to hope that they are listed for courts where we will have staff to be able to respond and support the judiciary in making a decision around a request for a report. We need to ensure that the IT supports the information flow and the communication of many different stakeholders and players in the court, right from the point of charge, in terms of working with liaison and diversion and making sure that we are able to get those health service assessments early, but also, as people will be aware now, we need to be able to access safeguarding and domestic abuse inquiries early in the system so that we don't cause delay in the court. And there are many, and in terms of the other end, the interface with sentence management, we need to be able to pass information over to our prison offender management and custody colleagues, or those people who are going to do the induction on a community order. Vital to have that information flow going through the system so that we can reliably respond to the different points within the sentencing process. We need to have templates and automation so that we are able to produce reports that are good quality, but also draw information into them so that people can not have to go in and out of different platforms. So this is a major rationalization of the IT infrastructure, which currently is very fragmented and makes is time consuming for those people who have to work under a lot of time constraints. And the final thing is it's absolutely critical that we have the information, but also the mechanism by which we can make good decisions that are evidence-based and supported through consistent practice, but lead to helping with the strategic planning around commissioning and the evidence base. So next slide, please. So the first tool that we would are introducing is called Prepare a Case for Sentence. It's kind of an all singing, all dancing platform for identification, for drawing information from our stakeholders and partners in the court. So it draws information from what will become, as Common Platform rolls out, which is the court system that's also rationalising a number of different systems. So it brings all the information from our systems, from court systems together, and helps with that early identification and the preparation that is needed before every court day. Next slide, please. We already have the effective proposal framework, which is the route by which we support. It's an algorithm, but it's an augmented decision-making tool, so it's not artificial intelligence as such. But what it does is help practitioners, having conducted a professional assessment, where they input the conclusions from that assessment, and on the basis of the criteria that is input, it will provide a menu of options for proposal. Those options will be backed by evidence where that is available in relation to sentencing guidelines, and also very much on the individual profile of the person that is being assessed, and that EPF 1 is there for courts and EPF 2 is there for resettlement, and that is also one of the ways in which we will help the targeting of interventions that are provided. The next slide actually is a video, and it is of a colleague of ours from data science, Zoe Walker, who was also responsible for the development of the effective proposal framework, and this is showing how we are developing an algorithm to identify those people who are at risk of short-term custody. If you recall, one of the problem I mentioned earlier was that you can't easily identify people who are at risk of short-term custody before they are sentenced. So over to you now.
Hi, I'm Zoe from the Probation Data Science team, and I am here to explain how we're going about predicting whether someone is likely to get short custody. We know that the National Court Team want to flag up 3 kinds of people as early in the court process as possible, so they can help prioritise pre-sentence reports. Females and young people, well, they're easy to spot in the data. You don't need data science to show you those. But people at risk of under 6 months custody is harder. We thought data science could do a better job of this, so we offered to help. We're going to try and predict this cohort. Data scientists are like scientists. They like a good research question to get them going. So our research question is, can we predict which defendants are likely to receive under 6 months immediate custody before their first court appearance? The before bit is crucial, as the first time you step foot in court could also be your last time. You can get convicted and sentenced in 1 court appearance. So if you want to do something proactive, you have to predict before the first court appearance starts. So the what and when are there. The how, well, it's going to be an algorithm. But first, how is this being done at the moment? Basically, we're using one score, OGRES, in itself an algorithm actually, which gives you the probability that someone is going to offend in the next 2 years, basically. If the last OGRES that someone had is over 50, it's a yes for risk of custody. If the last OGRES that someone had was under 50 or hasn't been calculated before, then it's a no. But OGRES was not made for this purpose. And for this purpose, it doesn't perform super well. More on that later. Ideally, you should always use algorithms for the specific purpose for which they're going to be used, because how you make them matters. So how can we do it better? We're going to make an algorithm, but we're going to use loads more data than just the OGRES score. Things like the other risk scores we know about people, information about their social characteristics, their needs, the court they're going to be in, the offence they're up for. And our algorithm will be able to give you an increasing probability between 0 and 100, which could be then chopped up into a yes or no, and you could pick a threshold within that, or it could be left nuanced as a 0 to 100 probability. It's important for us to ask what our models are likely to be used for, because how we want a model to perform and how its performance is measured needs to be linked to the purpose. Based on how the risk of short custody is being used currently, our prediction will not be used to mind read the judiciary or suggest what sentence to propose or change or impact other risk assessments. It could be applied better to spot who we could proactively suggest would benefit from a pre-sentence report, to refine the current way that this cohort is being flagged, and to better define this cohort. This cohort is already being used, it's being chosen as a target. It's not our decision to seek it out, but we could just try and make it a little better. First, a bit of explanation about how you can measure a model. This in itself is an ethical decision and really depends on what you're going to do with the model once you've got it. So we want to predict people who are at risk of short custody so we can do something positive about it afterwards. Suggested pre-sentence report. Therefore, it's more important for us not to miss anyone out, to reduce the false negatives, which is called trying to maximise the recall score on the right hand side. If it was more about not getting any false positives, not catching someone that isn't, then we'd want a good precision score. But each of them has a downside, and the little diagram is my fishing analogy to help me remember which each one does. So imagine catching fish is like trying to catch the people who are at risk of custody. Precision will catch only fish, no rubbish, but will inevitably also let some fish escape. Recall uses a bigger net, catches nearly all the fish, which is great, but will also catch a lot of rubbish and will take a lot of more resources to sort it all out. So in our case, we care more about recall than precision. But if all we cared about was not leaving someone out, we could do this really easily by just making a massive net and putting everybody in it and saying everyone's at risk of custody. That's obviously wrong too, because it means a lot of noise in the data. So there's a score called an F2 score, which is even better. It's a clever score which wants both things, but puts twice as much weight on not getting a false negative as it does on not getting a false positive. A good way my data scientist explained this to me is imagine our algorithm is going to get fined £10 every time it says someone's at risk when they're not. But it will get fined £20 every time it leaves someone out that actually turns out is a risk of custody. The algorithm is just trying to pay the smallest fine overall. We've done analysis of how well OGRS currently works on F2 score, and it comes out as 29 out of 100. But you basically want it as high as and close to 100 as possible, so there's definitely room for improvement. So what do we need to make a model? Spoiler alert, we haven't made our model yet, but we have to do 3 things before we do. So first, we have to decide what data we want to train it with. What things do we think might make a difference to someone's chance of getting short custody? We did this by doing a variables dartboard where we brainstormed as a team what we think mattered. And we then checked our assumptions by doing a card sort with real people working in courts who've seen people get sentenced and using their anecdotal and life experiences. We basically gave them the cards with our variable ideas on them and got them to rank them in a sort of really makes a difference to a person's risk of short custody to doesn't make a difference either way. Next, we've clarified the prediction point has to be before the first court appearance, as explained earlier, but that means we won't have as much data available to us at that point. So we've checked what data we will have available. And we can still find out a lot of things at this point from a prepare a case for sentence digital service, which shows us people who are due in court in the next few days, who they are, what they're up for, and so on. And then, because most people at risk of custody will have been known to probation before, we can also use information and assessments and data in our DLIS and OASIS systems about these people from the last time they were on probation. We will mix all of this together to create a data set used to train a model. And that's where we are at the moment. So the next stage is the bit our data scientists like the most, what I call the model Hunger Games, where we'll try out a few different machine learning techniques to train a model to predict, because there is more than one way to train an algorithm. Some will get great results, but will be complete black boxes. So it works really well, performs really well, but a human couldn't look in and explain and understand why, which is pretty scary accountability wise. Other models will be a lot more transparent, It's easy to understand how they're making up their minds, but that's because they're not as complex or clever and therefore might not perform as well. We basically want the Holy Grail, which is great performance, but in a way that we can understand how it's working. So we'll test all of these options against our F2 score, and only if we can do it better than Ogres, so beat 29 out of 100 essentially, with a model which is sufficiently transparent and explainable, will we release our model into the world. So that's a little bit about how data science is trying to help solve this problem for the National Court Team, and I hope it was useful. Thank you very much.
Thank you, Nat, for providing the video from Zoe, which is really interesting. And actually, just in terms of the timescale for that, we are hoping to have the predictive capability of the algorithm Zoe described in place by September, October this year. And what we will be looking to do then is make sure that our targeting around ethnic background, women, young adults, and risk of custody, plus the work also looking at vulnerable victims, is ready to be implemented for the new calendar year in 2023. So that was an example of one work stream of the National Court Strategy. If we took you through all of them in relation to the training offer, the judicial engagement plan, the work around making sure that we have good measures to understand exactly what we are achieving against the National Operational Court Strategy, and some of the whole system approaches that we are applying. I've mentioned the liaison diversion service in health particularly, but also with other services, the good partnership working with HMPPS and other court user colleagues. If I went through all of that, then this time slot would just be insufficient, because it is a very wide and demanding programme. But this last slide, I would just like to show that we are confident that we will achieve the objectives of the strategy, and that it is a realistic programme. And one of the reasons for that, not least of all, is this has been a significant investment in court work, with approximately 35% uplift on current staff in post during 22-23. The caveat to this is it's subject to our ability to recruit, which is, as people will be aware, in terms of the job market right now, and also our ability to secure the right people for a highly skilled service will be demanding. But it's going to be essential if we are to meet that 50% increase in forecast demand that I mentioned earlier. And the other thing is we also, I don't want to be negative when I'm actually making a positive point, but you have to be realistic, is that there are many vacancies in sentence management as well. So it's also contingent not just on recruitment, but also deploying staff in court to make sure that we are properly equipped to get that best start at the front end of the system that is required. But nonetheless, the fact that we have secured that increase and that intention to invest means that we have the right start in that objective alone. In terms of our work with the judiciary, who are the primary group of people who we want to engage with and to show that we provide value in informing their sentencing decisions, we are getting the positive feedback that I showed earlier, and like I said, that the senior presiding judge was very positive about the importance of pre-sentence reports. Although this is a kind of diametrically opposed to the what the judiciary thinking, it is also very important to us that the government see the importance of pre-sentence reports. The judiciary would say they were not influenced by government and politics in that way, but given that the judiciary, the government are also the ones that invest in public services, then it's important that they are persuaded that there is value in the work that we provide, and we have that backing. The HMPPS protocol hasn't been formally launched yet. There's a slight glitch, something around estates, which seems very minor in the scheme of things, but it actually has been signed by by the leads for HMPPS and HMCTS, and therefore in principle is fully signed up to. And this gives us that opportunity to really get into the detail about what it is that we are looking to achieve together, and bring to reconcile that tension between the need for quality in terms of advice to the judiciary and the need to ensure that there are no unnecessary delays in the court for the benefit of the victim, and also to manage the recovery backlog. And in terms of the big change that we want over time is for culture change in the court. For too long it has been seen to play second fiddle, and both in the courts and also in relation to sentence management. If you work in the probation service, you'll understand what I'm saying here, and that has to change. We have to say that court is a very attractive place to work. It's fast-paced, it's exciting. It is actually the purpose of sentencing is clearly the starting point in the justice system, and we are asking people to do a very difficult job of assessing complex issues, or people with complex issues, and provide the court with the best available advice for that sentence decision, whilst also, as I say, to get the best start for the individual before the sentence actually begins. And so what we are looking to do is make the place an attractive place to work, where we are able to attract the talent in the probation service who want to come and provide that professional service in a host environment which itself has its attractions. So we're really positive about that. It's a quick canter through a lot of stuff, but I'm hoping that has given you a flavour of what we intend to do in the future, and how we intend to make it happen. And if you have questions, I'm more than willing to answer them, and if they're really difficult, I'll ask Kelly to. Thank you.
Well, we have a question in the chat, Richard.
I have a question in the chat.
From Gwen. So can you say any more about local engagement with courts to enhance confidence at that level?
Actually, this might be a bit irregular, and I don't want to put it on the spot, but Natalie is our our judicial engagement manager. So Natalie, would rather than me blathering about the detail that I don't have full grasp of, would you be able to answer that?
Yes, thanks for putting me on the spot, but I can actually answer this one. So this has been something that we've been looking at quite closely over the last few months, and we actually completed an audit which looked at local engagement and national engagement regionally, and in response to that, regions were given feedback and action plans, which they're then able to take forward and look at how they can kind of enhance and improve their engagement. It looks at things like the various meetings, there's a newsletter or update that goes out for the regional director, so it looks at the consistency and the quality of local relationships, and yeah, I think that sort of kind of answers that question. But I don't know if Kelly, I think Kelly is on the call, so I don't know if Kelly has anything to add to that.
Hi there. Hello. Yeah, I guess the other thing to say is that obviously what we're looking to do nationally is to support regional engagement, because actually what we know is that local engagement, how important that is in terms of everything from the relationship that we have with HMCTS, from our morning meetings with the clerks to look at planning for the day, all the way through to some of the meetings we might have with the judiciary and judges. So from a national point of view, we're looking at how we can best support local engagement, but also, as Natalie's highlighted, look at some of the consistency. The next piece of work we also want to do is look at our feedback that we've had from on the judicial survey, because that's an important part of our engagement activity. And we're going to have a look to see how that compares to what's happening locally. So actually, if we're seeing higher response rates to the survey, or higher response rates in terms of how happy the judiciary are with the work that we're completing, reports, etc., we're going to look at how that links in with the engagement that's happening locally in those areas, and to see what the correlation is between them. But yeah, I don't know if there's anything else further they wanted to ask around local engagement.
I think the one thing, given that this is about future of the probation service,
Yeah,
this shouldn't be a future thing, because we commissioned it a long time ago, but we are waiting for the production of what is called the judicial engagement dashboard, and it's essentially that shows the quality of the work and the amount of work that we do in the court, and as I mentioned earlier, shows also the success of the work that we do in running the sentences that the judiciary pass. And one of the things when we were showing an early version of this to judicial colleagues is, and particularly Crown Court judges actually were saying they were stunned at the level of success we had in completions around unpaid work and accredited programmes. And we were a bit baffled by this. And they said, well, if you think about our position, all we see is the people that come back that have been breached. And so therefore our first-hand experience of the success of the probation service is actually not the successes but the failures. And so it's fantastic to see that unpaid work completion was around about 80%. I think it was pre-pandemic, and so we're not haven't got the data, the current data to hand. And I think that accredited programme completion rates were at around about 75%, and they were actually very impressed. So I think that what we need to do is be able to show the data and the evidence that gives both our successes and failures, because I think that in actual fact it's about having an honest, clear, problem-solving conversation with our colleagues and judiciary in the court and judiciary in particular, to look at how we can improve what we do, but also give them the confidence that we are driving things in the right direction when it comes to the running of sentences, which of course is what gives them confidence.
Just to add to that as well, something that Kelly mentioned about the judicial survey, and something that came out of the 2021 judicial survey was that something that arose out of COVID and the way things were managed during that time was that a lot of the engagement with judiciary meetings specifically were able to happen online, and actually the attendance in those went up. And that was reflected in the survey about something that they appreciated and enjoyed doing. So that was something about moving forward. I think there's a lot more leaning towards continuing in that manner as well. But there's been another question in the chat, Richard.
Yeah,
from Michelle.
Michelle,
Yeah.
Thank you, Michelle. That is an excellent question. It's also a very complicated question, but let's start with what you're suggesting there, and that is that we have we have experienced practitioners in the court. I think if you can manage that, then that is a really good approach, because I think what it demonstrates is that this is a difficult and highly professional job that has been underrated. What I would say though is, in terms of new, what we want is, I guess, is probably a mix of experience, because we also want it to be viewed as being an exciting starter job, that this view that you have to cut your teeth in sentence management before you become a fully fledged probation practitioner, I think is incorrect. And I think that the transferable skills from sentence management to court can easily be identified and applied, but equally I think that ability to be able to assess quickly and accurately and make confident decisions in it will equally transfer to sentence management. But this is multifaceted. It's about culture change, it's about training as part of that, but it's also about leadership. It is about the engagement and building the confidence with not just the judiciary but with other court colleagues, and I think that our relationship with HMCTS will be key to the feeling that we are operating on within the court with equal status, and that the primacy of avoiding delay is equally matched by good problem solving around how to make sure that we get quality assessments to the judiciary for decision making. That's always going to be a bit vague, unfortunately, because it's something that's definitely work in progress. How do we reconcile the expectations? Sorry, all the questions are coming through. How to reconcile the expectations of the judiciary for a report to be provided expediently? the services requirement for forms, etc., to be completed. You may have answered your own question there, Rachel. I think IT is definitely part of the solution, but actually it is more than that, and I don't want to completely go off piste, but I will share some of the dilemmas that we are currently working through when looking at pre-sentence reports in particular. And this all speaks to providing value for the judiciary. So we know, as a lot of public services do, that the inspection regimes will be a big influence on what is considered to be quality and how you evidence the quality that you are providing. We also have a variety of policies that place expectations on themes and issues to be addressed within pre-sentence reports, whether it's safeguarding or whether it's diversity or whether. So there are a whole host of things that are required to be in pre-sentence reports that are unrelated to what the judiciary might necessarily consider to be value, but are important in their own right. So don't get me wrong, I'm not. So what we are looking at is a way that we can actually provide the judiciary is what they need to make a decision without having to also provide the evidence in that same product that tells the person who is auditing it that these issues have been considered. And part of that might be a way of having a checklist, but it might also be about how we observe people doing their job in order to be able to see that consideration is being given to these issues when formulating a conclusion, but we don't have to throw the kitchen sink into the report just to demonstrate that. So I think there is a tension between that internal drive of public service to show that quality is being delivered, but the definition of that quality is very much driven at the moment by what the Probation Service to be considered important rather than necessarily what the judiciary considered to be important. And the final point to make on that is that that also relates to what we are looking at in terms of the difference in format. So at the moment with oral, fast and standard, none of those terms particularly make sense. Certainly fast isn't fast always. And we are looking at whether or not in terms of that purpose of the report that we would have reports that specifically provide information, particularly for punishment, and say this is entirely suitable, but do that quickly, where there is, and we are able to identify those cases that require a degree more complexity, then obviously that might require adjournment and more time to consider those issues. In terms of the filling of forms, some forms are critical because they provide information on how to improve the service, and some forms, if they are simply to, as I say, provide a means of serving internal drivers rather than increasing quality in the report, then they will be under review. There's a lot of change going on in this space, but not many firm conclusions as yet, and I don't want to completely talk out of turn because these things have to go through governance before they become policy. But I suppose the encouraging thing I'm saying is we understand the point that you're making, Rachel, and we are looking at it. Okay, unless anyone sneaks another question under the wire, I think it's probably a good time to bring this to a close. I think I was saying that it's been a privilege to do it. Really helpful to be able to try and set out what we think the future of the probations of court services and probation court services will be. Not the too far distant future either, actually. I mean, we haven't gone for the kind of wish list. We are trying to present you with something that is based in reality, based in part of the reform programme, and ready to implement in 2023. So, thank you very much. Goodbye.